invite the first panel. I think we only have 2 people in Flash and then 2 people in the digital form. And they will discuss overall recent trends in treaties and cases, as well as admission and national security issues on ISDS. And Professor Can Yeginsu from 3VB in London will be chairing this panel. Can has been a long-standing member of the Investment Treaty Forum. He does work not only on international arbitration, investor-state arbitration, but also in human rights and in some other public law areas. Over to you, Can. Thank you.
Thank you very much, Jarek. I just want to check that we can be heard online.
By the way,
great.
Yeah, and there are 2 messages in the chat box. I hope they're not saying that we can't hear anything.
Yes, just
okay.
Checking.
Just thank you.
Great. Good. Well, good morning to you all, and a very warm welcome also to those joining us online. It's always a pleasure to be back at the ITF's public conference. It's my privilege to chair our first panel today. As you've heard, this year's conference theme is Evolving Standards of Investment Protection. And our task as the first panel really is to set the scene for the discussions to follow. We'll be looking broadly at how standards of investment protection have evolved, but we'll be doing that through the twin lenses of treaty practice, but also arbitral jurisprudence over the past decade or so. Really, for our present purposes, 3 big themes stand out, and it's those 3 big themes that are going to be the focus of our discussions on this panel. First, the shift from the older, arguably more broadly drafted investment treaties to the more carefully delineated and sometimes more restrictive formulations that states have increasingly adopted in recent years. Second, the growing prominence of admission and national security provisions, both in the negotiation of new agreements, but also in the disputes now testing their limits. And third, the trajectory of investor-state dispute settlement itself, the changing volume, the changing profile of the cases, the sectors that are now being most affected, and the persistent questions surrounding damages and methodology. I'm joined this morning by 3 distinguished panelists who approach all of these issues from slightly different vantage points. You'll hear perspective of the international organization, perspective of intergovernmental policymakers, and also the perspective from private practice. Now, let me start by introducing Dr. Joachim Pohl, who joins us from Paris, I believe. And Joachim, I hope you can hear us. We can see you. Joachim heads the International Investment Governance Unit at the OECD. And since joining the OECD back in 2003, he's led the organization's work on investment treaty reform and on investment security. We also have joining us online, I believe, from Geneva, Diana Rosat, who is an economic affairs officer at UNCTAD with more than 13 years of experience in research and capacity building, focused, of course, on reform of investment treaties and investor-state arbitration. Next to me in person, we have my old friend, Dr. Markus Burgsteller, who is a partner in the international arbitration practice of Hogan Lovells here in London. Markus advises on public international law, on EU law, and acts for both investors and states in arbitrations under various rules, including ICSID and CITRAL and the ICC. I also believe he serves on the ICSID panel of arbitrators, having been nominated by Austria. So each of our panelists will kick us off with short presentations. Joachim's going to begin with the evolution of treaty drafting. We'll then hear from Markus on admission and national security issues. And then finally from Diana, who'll provide us with a broad overview of the key general trends. And after those speaker presentations, we'll have a moderated discussion, open the floor to questions, including, of course, from our online participants. So with that opening, Joachim, I'm going to ask you to, or invite you to kick us off, please. Joachim, just pause one moment as we try to make sure we can hear you. Could you try again, Joachim? No? No?
Now it should be fine.
No?
That's what I'm confused. How about Diana, if she says something, then we'll know whether it's a problem.
Yes.
Whose problem that is.
Do you hear me?
Yes.
Yep. Okay.
So,
I don't hear Joachim.
Maybe disconnect your headset, Joachim, and then use your laptop microphone.
and if we can't, we may just change our order so as to give Joachim some time without the whole room looking at him.
Does
There
that
we
work
go.
now?
Yes.
Good, excellent. It just
Wonderful.
worked before, so I was surprised. Well, anyway, apologies for this little hiccup, and thank you, Chair, for the introduction. Now, let me also start by thanking BIICL for organizing this event and for inviting the OECD again to this discussion. I apologize for not being in the room with you, as I would have liked. The OECD is a poor organization, and even traveling from Paris to London is out of our reach financially speaking. But Jarek, I assure you that I'm in the flesh. What, you may ask, can the OECD contribute to the 44th conference that it has not already contributed to the first? Now, the OECD has been a forum for governments to discuss investment treaty policy for decades. For them, in that role, the OECD Secretariat has been preparing detailed studies on the design on investment treaties, specifically large sample studies of treaty designs. And in these studies, which are all publicly available, I'll show you where, we look through roughly 2,500 treaties individually to statistically describe the design of these individual clauses. Now, I've been asked to present on the differences between new and old generation international investment agreements. And that requires some clarifications on the notion of new and old generation first. If I don't miscount, there are at least 6 generations of modern IAs, not counting FCNs and the like pre-1959. Now, first there were the BITs without ISDS. And it took a full 10 years for ISDS to emerge in BITs and another 10 years to establish itself as the norm. Now then, third generation came the market access pre-establishment series of treaties starting in North America. Then came the plurilateral IAs. And then, and this has been alluded to, and I guess it's my topic today, as of the early 2000s, we observed the design change in the framing of substantive obligations and to some extent of ISDS. And even more recently, we can identify a next generation of treaties that have sustainability content. So the concept of old and new generation might be understood quite differently. For today's presentation, new generation means treaties post-2000 that contain, in the framing of substantive treaty obligations, greater detail and specification. These treaties state more clearly what the scope of substantive obligation is and how these obligations are to be interpreted and applied. I should mention that there have also been developments with respect to ISDS, but I will not talk about these developments today. Now, at the OECD, we have studied in detail 5 substantive clauses in around 2,500 treaties that were concluded over 6.5 decades. These are index expiration, FET, MFN with respect to dispute settlement, FBS, and national treatment. I should emphasize that seen from today's perspective, individual treaties may be partly new generation and partly old. The trend towards a more specific framing has not started and spread exactly at the same time for all clauses and not at the same pace. Overall, roughly 200 treaties have so far been designed that have new generation features, counting bilateral and plurilateral treaties once. Now, what is going on specifically in this area? I will use the example of the FPS clause to show the changes. Professor Ortino mentioned that the first conference in the series was about an OECD report on FET, and we thought that some variation would be nice. Hence today, 44th conference, FPS. Now, the FPS clause is representative, or what we can observe in FET, IE, and MFN as well. So this is why it doesn't really matter what clause I use as an example. Now, until the early 2000s, treaties did not specify what the notion of FPS encompassed and what behavior host states owe to investors. And I'd like to show you some images to underscore this. So it's easier to grasp the evolution. I hope you can see the slides.
We can.
I hope you can now.
We can.
Yes, good,
Yes.
excellent. Look, some things work. Now so in the beginning until 2000, these treaties did not specify what FPS encompassed and what behavior host states owe to investors, other than it had to be constant, full, and the like. Now, I will call this design unspecified FPS clauses, although I admit that the word indeterminacy that Professor Ortino used in his keynote is more beautiful. Now, this is what happened. At the turn of the millennium, we see a rapid decline of the use of unspecified FPS clauses, here shown as percentages in annual treaty cohorts. So all the treaties of a cohort are shown in 1 year up to 100%. And so the light gray shows unspecified FPS clauses. And you can see until 2000 roughly, that was the norm. Now, this design is then phased out progressively, as you can see, but swiftly, beginning in the early 2000s. The design that we see instead contains a much more specific framing of the obligation, and this is what you can see here. Now, here again, we see annual cohorts of treaties concluded in a given year, and the new treaties express that FPS is limited to physical or police protection. That's shown in dark gray, in blue, and that it is limited to MST, customary international law, or both. And you can also see that in recent treaty cohorts, every single treaty has this design. And when looking closer, that the combination of police physical and the link to MST, customary international law, is now universally used for FPS clauses in all new treaties in the sample and has been since 2021. So in essence, there were a few decades in which unspecified decades of FPS clauses were de rigueur, and after a transition period where older and newer designs were used contemporaneously, we now see exclusively the new clarified framing of FPS clauses. Now, when we assess how this practice has spread across jurisdictions, we see a progressive shift towards the new design approach. On this timeline, starting mid-80s to today, essentially, we can see when the new design was used for the first time by a jurisdiction in a black dot. And then we see a period in light gray when the design was occasionally used. And then the dark gray shows since when this design of FPS clause was systematically used in all treaties consistently. Now we see that some jurisdictions have used the new FPS design systematically since the early 2000s, and some have started to consistently use it later. Now in this slide, you see the full country samples. But I recognize you can't read the country names, but what you can see is that roughly since 2014, almost everyone uses this new design, a clarified framing of the FPS clause systematically and consistently. So we have a clear movement of basically every jurisdiction towards a systematic use of new designs, which is specifying what the FPS obligation encompasses. Police and physical protection, captive, MST, CIL. Now, when you ask governments whether the change in design represents an evolving standard of investment protection, this is the theme of today's event, they will say no. The standard of protection is not evolving. What is evolving is how they frame an express list standard. But the standard has always been the same. It was only poorly expressed as governments realized that interpretation and litigation deviated from their intent. I think we will see in Diana's presentation when ISDS took off, and we will see that as soon as the first arbitral decisions came out, the design of the clauses changed. But the standard of investment protection did not change. Now, back to FPS. So the clear and market trend towards a clarifying framing of FPS does not mean that the older generation treaties are gone. If we look at the treaties that are in force at the end of each year, we can see that the share of treaties in force that have new designs is growing steadily, as shown here in dark blue. The light gray at the top are the share of treaties that don't have FPS at all, and the dark gray are the treaties with unspecific FPS designs, apologies. So yes, the share of new generation treaties in the sample goes up, but the old treaties do not go away and remain in the overall population. And that even holds when we project the treaties, as done at the very right, to include those that we know will be replaced or end otherwise, and count all treaties that are concluded but not yet in force. Now, the overall treaty population will actually continue to contain primarily treaties with their old unspecified designs side by side with those that feature new designs of the same clause, here the FPS clause. Let me conclude here. Thank you very much.
Thank you. If I could just ask a follow-up question before we move to Marcus by way of clarification. I mean, do you see this drive towards perhaps greater textual precision extending also to other standards in treaties, or is FPS in some way uniquely affected?
Yes, thank you for that question. Yes, so the same observation is made for index variation, FET, and MFN with respect to its interaction with dispute settlement. The graphs look frankly the same, even though the timelines, the drop-offs, and of the old designs and so on are not identical. I referred early on to treaties that have old and new features, and so this applies to some treaties having a new IE design, but not yet a new FET design, for instance. I should also mention that this applies to the homogeneity of government's intention over time. So for FET, for instance, and I thank Professor Ortino for mentioning this, I quote from a 1967 edition of the Draft Convention of the Protection of Foreign Property. And that contains the full text of that convention, including, crucially, its annotations, which form an integral part of the draft convention. It reads, the phrase, fair and equitable treatment customary international in relevant bilateral agreements, indicates the standard set by international law. The standard required conforms in effect to the minimum standard which forms part of customary international law. I'm quoting for a book that was edited in 67 and written in 62. So the thin air question is frankly there, right? There was a clear government intention when they wrote FET clauses that FET conforms, I quote, in effect to the minimum standard which forms part of customary international law. So for FET, we have actual evidence, it's not often reproduced, but it's there, that you can see from the very start, the early 1960s, government developed modern IAAs, and that meant, even at the time, CIL MST when they said FET. And so they admitted that later from the bits, but that doesn't mean that they didn't mean it. So same empirical observation on the frame of substantive obligations, and evidence their intention has not changed over the decades. Now, if you're interested in the detail, I show you the slide. This is the link that brings you to the other statistical service where you can see how these graphs look for the other clauses. Thank you.
Look, I'm sorry, I'm going to have to provoke now because what you said might be felt to be controversial by some. When it comes to FET, and you took us back to, the attempt at a Magna Carta for investment law. Of course, when it comes to bilateral investment treaties, some states, such as the United States, set out in terms, whether it's in bilateral investment treaties or whether it's in bigger agreements like NAFTA, that FET is equal to CIL. But many states didn't set that out in treaties. So I just wonder what you say about that, because of course the premise presentation is the intention's always been the same, but the states are possibly surprised by how some of these treaties have been interpreted on the anvil of individual cases. So all they're seeking to do is to clarify. But would you also say that for treaties where arguably there's an autonomous standard in FET?
Yeah, thank you. Look, if I wouldn't say things that were slightly interesting, I shouldn't be speaking at all. So yes, no, that might be controversial. The question is, where does this autonomous standard come from? And because, yeah, we don't have much evidence that this autonomous standard was planned somewhere. At least I don't know about it. So, and I can't speak for governments, right? I hear what governments say, and I can parrot or repeat that. But so what I can present to you is evidence on what governments, at least at the time, I think there were 14 founding members of the OECD, what they thought, and whether an autonomous standard was then developed at some point. Yeah, maybe. So I'm only giving you the evidence, and I'm not going to interpret that. But I think this is interesting and rarely ever seen. Right, this is a very, very old text, 62. This was before the, 10 treaties had been concluded, 10 BITs, where governments said that. They probably meant it.
Joachim, thank you so much. Marcus, perhaps you can pick up the thread from there and take us into the national security dimension.
Thank you. Thank you for the kind introduction, and thank you to BIICL for the invitation. The transformation of the geopolitical context in recent years has meant that national security issues have assumed an increasingly prominent role in shaping investment policy. Foreign direct investment inflows have decreased while screening has increased, especially in G20 states. Several states have sought to strengthen and intensify the foreign investment screening regimes. Some have introduced such regimes for the first time, while others have expanded their scope, including through allowing for retrospective screening of investments. Similarly, the list of sectors subject to such screening has expanded in several states, covering the likes of AI, semiconductors, surveillance, critical infrastructure, and data. These sectors are among those considered to be most at risk for weaponized investment, whereby foreign direct investment, which appears commercial on its face, is strategically used for geopolitical objectives, including espionage. Critics of screening regimes refer to a different type of weaponization, claiming that it is in fact national security concerns that are weaponized to achieve political goals at the harm of commercial investments. They perceive these screening regimes as a new method of lawfare. States have the inherent right to regulate their affairs and adopt laws in order to protect genuine national security interests. Several tribunals have accorded a high measure of deference to states to adopt measures aimed at the protection of national security. But this sovereign right takes place within the confines of the state's international legal obligations. It must be balanced against the protection afforded to foreign investors under investment treaties, in particular in relation to the fair and equitable treatment and non-discrimination standards. Investors have begun to challenge measures allegedly taken in the name of national security under investment treaties, including as a result of investment screening regimes. Most recently, in last month, it was reported that Hikvision, a surveillance equipment manufacturer partly owned by the Chinese state, has sent a notice of intent to submit a claim to arbitration to Canada under the Canada-China Investment Treaty. In June 2025, the Canadian government ordered Hikvision to close its Canadian operations because they would allegedly be injurious to Canada's national security. The order to close was made pursuant to Canada's Investment Act. It remains to be seen whether a claim is ultimately then brought by Hikvision. Most notably, in 2022, the Chinese technology company UI brought a claim against Sweden over its alleged exclusion from Sweden's 5G telecommunication network rollout. I will discuss this case in a bit more detail later. In the remainder of my remarks, I will first discuss recent trends highlighting the increasing prominence of national security issues in ISDS, including the UY dispute. I will then consider how investment treaties address national security issues, including in new treaties. I will then address admission. Several investment treaties require investments to be made in accordance with host state law or simply to be otherwise admitted. These provisions are designed for states to strike a balance between encouraging foreign direct investment and preventing unconstrained investment flows from threatening national interests. Starting with national security trends. The question which now frequently arises is their interaction with investment treaties. In the majority of cases, with the noted exception of many US treaties, investment treaties protect established investments. In other words, to protect investments that have already been made rather than securing market entry. However, recent provisions for retrospective screening, that is the review of already established investments, increase the risk of investment treaty claims. For example, the 2019 EU screening regulation does not provide for retrospective screening per se, but does include a mechanism pursuant to which an EU member state can provide comments, or the EU Commission may issue an opinion up to 15 months after completion of an investment that has not undergone screening. In such circumstances, necessary mitigating interests may be taken against such an investment. Such measures can include operational restrictions, information and technology controls, approval obligations, or even divestment requirements. Similarly, the UK National Security and Investment Act 2021 gives the Secretary of State a so-called call-in power. This relates to actual or anticipated trigger events. These are events whereby a person or entity gains control of an entity or asset in certain sectors. If that event may give rise to a risk of national security, a call-in notice can be given within 6 months of the Secretary of State becoming aware of it, and within 5 years of its occurrence. If the Secretary of State is convinced that, on the balance of probabilities, there is a risk to national security, they may issue a final order, which may include a requirement that the relevant investor do or do not do particular things. And this type of retrospective screening is more likely to give rise to potential conflict with obligations under investment treaties. By contrast, a minority of investment treaties takes a broader approach and may cover pre-establishment investment screening. This depends not only on the definition of investor and investment, but also on the terms of the relevant obligation. For example, the definition of investor in the US model BIT includes a party or enterprise that, quote, attempts to make an investment. This may cover market entry screening depending on the definition of investment and the substantive obligations. The pending UY against Sweden case, which I mentioned earlier, is a good example of a trend of cases we may see where tribunals are required to balance national security needs with the standards of protection in investment treaties. This dispute under the Sweden-China BIT arises from UY's alleged exclusion from Sweden's 5G telecommunications network rollout. In 2020, Sweden invited all major mobile networks to auction for licensing rights over the upcoming Swedish 5G network. The 4 shortlisted networks to participate in the auction were required not to equip their network with product sourced from UY. This requirement and the resulting auction meant that all future licensees were prohibited from using any of UY's equipment or services in the network for 25 years. And such equipment and services already in use for existing 3G and 4G networks had to be phased out by 2025. This was not a case of market entry. Rather, UY had a very well-established presence in Sweden. According to publicly available information, UI has argued that Sweden's allegedly unfounded security allegations breach the investment protection standards in the BIT and are likely to have a spillover effect on other European countries, amplifying UI's reputational and commercial harm globally. The Sweden-China BIT does not have a national security exception clause. Such clauses may specify that states may take measures for essential security interests. Other treaties, such as the Canada-Egypt BIT, as seen, for example, in Global Telecom against Canada, provide that screening decisions are excluded from protection. Canada's 2012 BIT with China, which may become relevant should Hikvision commence arbitration, excludes from investor-state dispute settlement a decision by Canada following a review under the Investment Act. Returning to the UI case, the absence of a national security exception in the Sweden-China BIT has led some commentators to argue that the tribunal may have more leeway to assess necessity of Sweden's claim that UI's infrastructure would be damaging to its national security. However, such concerns will have to be weighed when assessing legitimate expectations, transparency, due process, and discrimination. Recent treaty practice may suggest that, unlike in the case of the Sweden-China BIT, states specify national security exceptions. For example, a recent BIT between Bahrain and Korea, which entered into force in July 2025, contains an exception allowing the host state to adopt measures required to protect its essential security interests. A similar provision is to be found in the Venezuela-China BIT, which was signed in November 2024. Turning to admission, as I mentioned, several investment treaties require investments to be made in accordance with host state laws. If a treaty includes such a requirement, a proposed investment subject to national security screening would need to be permitted through that process in order to be an investment in accordance with host state law. In Global Telecom, the Canada-Egypt BIT had such a requirement, but Global Telecom could still bring a claim because it had pre-existing investments. The losses it claimed arose because the screening decision meant it could not acquire the company and was unable to recover the value of its pre-existing investments. Certain other investment treaties include obligations related to the establishment of investments. These allow investors to rely on treaty protection in relation to a national security screening decision, even if they do not already have a pre-established investment. Typically, only non-discrimination obligations are extended in this way. For instance, the US model BIT extends the national treatment obligation to cover the establishment of investments. Under this approach, we may begin to see more claims related to either prospective investments being blocked by national security screening, or arguments that screening of new investments affects existing investments. It may be the case that states seek more frequently to raise a defense based on necessity, but this is a very high threshold. The precise wording of the specific investment treaty, particularly in relation to admission requirements and any applicable exceptions or exclusions, is crucial in determining whether they can offer protection to investors whose investments are subject to national security measures.
Thank you very much, Marcus. Well, look, I mean, this area is only going to rise in importance, set against the developments in technology, surveillance, AI, etc., and the geopolitical moment we find ourselves in. Marcus, if you would allow me, there's a lot of extremely interesting material there. I just wanted to ask you, by way of follow-up, if you have an order from a Minister of State, say in this country, I want to keep it hypothetical to give you some room to maneuver in your answer, because this is an area that's still rising in importance. There aren't, 300 awards where tribunals have had to balance these competing interests. If an order is made by a Minister of State here, do you think, or in some other country where that order can be subject to judicial review, where do you see investors going? I mean, will they test this, do you think, in the courts, knowing that, you know, this is a point of real sort of state sovereignty? Or do you think they'll skip the courts strategically and go straight under the bilateral investment treaty, knowing that that will lead to the risk that the three arbitrators will feel very, very nervous about deciding whether or not a fair balance has been achieved?
I think it may depend on the jurisdiction in which the investment is made and to which courts you could have recourse to. If a decision was made in this country, I think the English courts are known to be impartial and are known to, you know, are also independent from any government influence. So I would think if a decision is made in this country, investors may first look to go to the English courts if there was a legal basis to go to the English courts rather than going under an investment treaty. So I think the answer is the usual lawyer answer.
Yes,
it will depend.
It depends. And I think it's a completely fair answer to a fairly unfair question. But I mean, it just strikes me that, you know, courts who are interested may also, in especially common law jurisdictions, have greater powers on disclosure, duties of candor on governments, which don't apply in the same way under bilateral investment treaties. Just one follow-up. How do you see tribunals, just from a perspective of methodology, balancing these competing interests? Because we saw this, you know, 20 years ago with tribunals really trying to work out if they've got an FET clause, for instance. Are they going to borrow margins of appreciation? Are they going to borrow proportionality analyses taken from other areas of international law? Do you think this is one of those areas where you're going to have to borrow from other areas of law to achieve a fair balance as a tribunal?
I think so, and tribunals are obviously always embedded in the wider political environment. It is very clear that a number of these decisions in the interest of national security are taken, and I think most arbitrators, as confident as they may be in their own abilities, will be very careful to second guess national security decisions, in particular if they are well founded and if they are argued reasonably on their face. I think most arbitrators would be reluctant then to say, I know better than the policymakers.
Yeah. Thank you, Marcus. And please get your questions ready for the end, because I could be asking questions forever, but I'm going to let Marcus off now. Thank you so much for an extremely interesting presentation. Diana, perhaps you can widen the lens for us now and take us out of national security and share what the latest UNCTAD analysis reveals about the trajectory of cases.
Yes. So we will go back also to some of the statistics and data mentioned by Professor Ortino in his introductory remarks. And I have personally also learned things from Professor Ortino in the past because he contributed to our work at UNCTAD some years ago, and also worked on the ISDS database that we had at the time. So I'm going to just put up my slides. Just a second. So I hope you can, I think I see that you see them. All right. So maybe one of the first questions is, when we look at the general ISDS trends, do we see more of the same, or have there been some recent changes? So if we look at how the cases evolved, and this has already been mentioned, so they started to trickle in relatively slowly. So we had these early also NAFTA cases, and then it started to grow. And so if we look at, so from 2010, we have seen the bulk of cases arising. And the numbers are, we have seen a peak in 2018 with over 90 cases. And last year we had about 58 cases. So the numbers are fluctuating a little bit. We are not seeing the peak of the cases right now also may be related to the COVID pandemic, that there have been there has been maybe some backlog in bringing cases and so on. But we can see, for instance, also that now it's also picking up 2025 at ICSID. So this may not be the definite, a definite decline. Now up. If we look at the broader dynamics, we still see more of the same, that respondent states are mostly developing countries. We have a share of cases against developed countries. Some of the cases have been mentioned, also in terms of national security cases. The cases are typically brought by developed country investors. So that trend is quite stable. There had been a change from 2010 onwards, where Spain has received this wave of renewable energy cases, and Spain is a developed country. So that makes also some of the percentages here for developed countries as respondent states. And as you can also see on the side, these are the most frequent, the 5 most frequent respondent states. We have Argentina on top now, also due to the old wave of cases that they have seen after the 2001-2002 financial crisis. Then we have Venezuela with an ongoing stream of ISDS cases against it. Spain with a lot of the renewable energy cases, so almost all of these 58 are renewable energy related. Mexico and Egypt. And now if we look down, we see the most frequent home states of claimants, and that picture doesn't change too much over the years. So we have the United States, claimants incorporated in the United States as the most frequent, most frequently bringing cases, with 234, Dutch investors, United Kingdom, Germany, and Spain. So Spain is the country that appears twice here as respondent state and as a home state of claimant. So this dual role actually also shaped a little bit of Spain's response to investment treaty reform. But I'm not going to go into too much detail, but many countries are considering this dual role that they have as respondents, but also home states of claimants. If we look at the economic activities underlying ISDS cases, so we have this broader trend that is also like more or less stable over the years, that we have a lot of energy supply and mining, oil, gas, coal cases. So 1/3 of them relate to these 2 categories of cases. What is new is that, for instance, in 2024, and we don't know whether this is a new trend that will persist, but we have seen in 2024 that the cases in these 2 areas have gone up. So they accounted for over half of the claims. And for instance, if you look at the dark blue, mining, oil, gas, and coal extraction, the case percentage has doubled. So this is the share of cases in 2024. So 50% of them related to energy supply or mining, oil, gas, coal extraction. If we look at the cases another way, so we can also count, for instance, and that is quite relevant now, right, with climate action, but also activity on new policies on critical minerals, and also changes in how to incentives on renewable energy. We have seen 249 fossil fuel related ISDS cases. So that's just a different way of counting them, right? But 249 out of 1,401 total cases is about 20% or 18%. Then we have at least 129 renewable energy related ISDS cases. So many a share of them are the ones against Spain, but there are also other countries that have received them. Italy, Bulgaria, and I think Romania, a couple of renewable energy related ISDS cases as well. And we also we have some older cases that were related to hydroelectric power plants and those type of things. But from 2010, basically, this is where the growth in this area had started. A new area that we have also now started to kind of track are cases related to critical minerals. And here we're looking at the broad group of critical minerals. If we look only at those ones that are related to critical minerals required for the energy transition, so a smaller group of particular critical minerals, we see 51 cases. And we also see that there is a rise of critical minerals related cases overall, and specifically for this group of critical minerals required for the energy transition. So I'll spare you the definition of these different critical minerals groups, but we have this in a recent publication where you can also have more details about these cases. Coming back to what Professor Ortino mentioned, that the share of cases won by states and by investors has been quite stable over time. So is there something else also happening there? And if we look at damages, the claims and the damages awarded, we do see some changes there, perhaps. So we can fact check that, whether this is just a general feeling or we can back this up with data. So we have a quite mixed picture if we look at all years and don't differentiate, right? So if we look at, for instance, in our database, everyone can check this. If you go to our investment dispute settlement navigator and you click on damages, you see an overview of cases by amounts sought by the claimants, and you can also sort by the amounts awarded by the tribunal. So most of the cases, looking at amounts claimed, we see most of them are between 10 million and 500 million. And then awarded by the tribunal, most of them, or the largest number, is between 10 and 100 million, right? So this, looking at this big picture, conceals a recent trend, actually. So when we start to look at different time periods, we do see something else there. So here, for instance, we looked at the average claimed until 2014 and the average claimed from 2015 to 2024, and the same for the amounts awarded, the period before 2015 and the period after 2015. And if we look at amounts claimed and awarded this way, we see that there has been a change. So we have seen an increase of 30% in the average claimed in ISDS cases, and we have seen a much steeper increase in amounts awarded. So there we see the amount has more than doubled. So from an average award of 100 million, we are now at an average award of 230 million. And just to add here, because this comes up, we also have looked at the mean value, not just the average, and the mean or median value also has increased. You can see this in our publication. We have different ways of showing it. And we have also taken out outliers. So now it's actually, we see two extremes: low values and extremely high values. And we also see a rising number of extreme values, extremely high values. So we have taken out the UCOS cases, for instance, from the awards awarded, and we have also taken out the Australian case where 200 billion were claimed from the average claimed, to just kind of avoid a little bit of the distortions of the overall average numbers. So what are the factors behind this upward trend over time? And you may actually know more than I do, especially practitioners. I'm sure you have very good insights on what is driving this. What we can see, and what has also been noticed, for instance, or discussed in the Ancestral Working Group 3 on ISDS reform, is this trend among tribunals to increasingly rely on the discounted cash flow method. So they are not the ones putting it forward, right? It's the claimants already putting it, using this in estimating their amounts, their damages. And so the shift towards the discounted cash flow method can explain this increase. There are also other factors, perhaps third-party funding, the role of damages experts, those type of issues, which you probably also know more about than myself. What we have done at UNCTAD, we also looked at policy options, because governments are looking into how to address this in treaties, and we have seen also some examples of that. And I would also refer you to one of our recent publications where we have looked at compensation and damages, and also have some examples of newer provisions addressing these issues. And I'll stop there for now.
Thank you very much indeed. I just want to pick up where you left off. I mean, from a policy perspective, how are governments reacting to some of the trends that you outlined?
I think one trend we haven't mentioned enough yet is that some are responding by not wanting to have ISDS anymore. So that is maybe a marginal position, but it has moved into a bit more of the mainstream with, for instance, Brazil developing a new model. We also see newer agreements by the EU that are focused on investment facilitation that have no ISDS. And there are these ISDS opt-outs under the USMCA or also under the CPTPP now with the UK signing side letters. So we have that trend of no ISDS, the broad picture trend. We have discussions about a standing tribunal. We have placeholders for that in recent treaties. And then we have this approach in new treaties for more limited ISDS, where you have more conditions and bringing cases or based on particular provisions and not all of the treaty protections that are included in the treaty. And maybe the last one is also fixes to the procedure, ISDS procedure. So that is one issue. And then for those treaties that retain ISDS, we have seen provisions addressing specifically tribunals' discretion for the methodology of damages. Sorry. Excuse me. So there are provisions that either provide guidance or are limiting that discretion. For instance, addressing speculative damages, hypothetical damages. So they're trying to put a cap on these types of claims that seem a bit excessive, perhaps, from some states' perspectives. So there is quite some innovation there, yeah.
Anna, thank you so much. That brings to a close the first part of this session, and perhaps take the opportunity to thank our speakers for what were 3 excellent presentations. Part 2, questions. Questions from the audience, questions from those joining us online. I would ask you, just as the chair, to make sure that you are posing a question and not running a commentary. And I would also ask you, please, before you ask your question to our panelists, to introduce yourself and to let us know your affiliation. Perhaps we can start with the boss.
Well, yeah. If I'm a boss, let's make an exception for me, because I wanted to comment that
Yes.
although we are not UNCTAD, but we did a lot of studies as well, empirical studies, and one which is relevant, I think, to this event is the study on cost, damages, and duration on investor-state arbitration, which we did with Alan and Overy a few years ago. And I've shared the link in the Zoom chat if anyone is interested.
Thank you, Jarek, for not leading by example. But thank you also for drawing our attention to that important study. So perhaps we can pass the mic round, please, sir.
Yeah, thank you, Graham Coop from Pinson Masons. I have a question which is directed particularly to Diana, though it could perhaps be answered by others. In relation to the last topic you discussed, which was speculative or excessive claims, are you thinking of anything particular? And in particular, is your research organized to distinguish between claims for investments that have already started to produce a financial return on one hand, and investments that have been financed and made but have not actually started to produce a cash flow yet on the other?
Diana, are you happy to have a go at answering that question? Not an easy one. Sorry. Yes.
So maybe also on the publication that Professor Krivoy has referred to. So I've also looked into this, and it's really very useful because it also talks about the costs for in defending cases for the investors and for the states. So I absolutely can recommend that study. And I have also looked at the methodology, how they looked at damages for this one. So as to the question whether we differentiate between for our database, or for instance, or for our analysis, whether the cases are concerning an investment that has happened or that already materialized, those ones that haven't materialized yet. So there is this, in Ancestral Working Group 3, there was a paper by the Secretariat maybe in 2021 or so, that looked specifically at the discounted cash flow and methodology and how to what type of cases this has been applied. And I think it found that it has also been applied to cases where the investment had not yet materialized, which was seen as kind of concerning or described as some concerning trend. So in our database, there is no way to kind of look this up quickly, right? Because it really depends on the cases, but it seems that even in cases where the investment has not materialized, there is an inclination to claim future lost profits. So this is definitely also an issue also for, and I think there is an event tomorrow, a BIICL event on damages. So perhaps Professor Krivoy could recall that as well, where this will also be discussed. And from the policymakers' perspective, these are exactly the cases that are also addressed in some of these newer recent treaties, where they say it cannot be speculative if there is no track record of actually making these profits. It's hard to claim anything but the money that has been actually invested and spent.
Thank you, Diana. Marcus?
Can I also ask you a question? And that is, I mean, you looked over a significant period of time when you compared, you know, the amounts claimed and the amounts awarded. Have you taken into account inflation and interest? Because obviously a dollar in 97 would not necessarily be a dollar in 2025.
That's to you, I think, Diana.
Sorry, go again. I've been reading the chat. I'm so sorry.
Have you taken into account inflation in your analysis?
No, we haven't. But the amounts have gone up so much, you cannot explain this with just inflation. Like it's, I mean, it's not magic. I don't know. Maybe London housing market is like this, but I'm not sure. Would you explain it with inflation, please? I'm happy to hear. Yeah.
Well, I haven't run a model,
yes.
But well,
yes. Thank you, Diana. Just to give you an opportunity, I mean, we won't have all panelists answer all questions, but would you like to contribute anything to this question, Joachim? And you're on mute, of course.
Maybe my technology mutes me. So we haven't studied cases as much. Governments are not as interested in cases as they're in the design, because they're in charge of the design and can only control to some extent the cases. So I don't have much to add to this. Thank you for Diana to take that. Thank you.
Yes, thank you. Small questions, sir, please.
Thank you. Joel Dahlquist from Arnold and Porter. I have a question for Marcus, and I should perhaps preface it by saying that we represent Sweden in the Huawei case that you spoke about. But my question is of a more general nature, and it is really whether you think investment arbitration really is fit for purpose to review and assess the type of national security determinations that you talked about. You were already asked about the tension between domestic courts and arbitration, and one could assume that domestic judges that are embedded in the state in question, judges that may receive security clearances and that may have significant tools available in the procedural sense to compel the state to produce things, to have in-camera hearings, to review classified documents, etc., that those tools aren't necessarily as easily available to international arbitrators. is that something that we on a more broad level think will affect how we view whether or not investment arbitration really should be addressing and reviewing and assessing national security determinations by sovereigns?
Well, if there is a legal basis for a claim, then I do not think that you can per se exclude that investors should be bringing these claims unless the treaty specifically excludes any such decisions. I would say that most arbitrators would exercise caution, as I mentioned, but the question is also if you say if there is a legal basis, they as the investors should not bring these claims or should not be allowed to bring these claims. Where do you draw the line? So if there will be many cases which have national security interests at their heart, but there may be others which may have some sort of national security element. So if you take a position that just because some national security interest may be at stake, that you say, well, that claim should not be brought, and I think you're on a slippery slope, and that may be something that one needs to look at very carefully, I think.
Can I just flip that for a moment, because it's a fascinating question. Again, it's a question that it's difficult to provide a specific answer because, you know, the considerations at play at Sweden may be different to the considerations at play for Kazakhstan, considerations at play for Australia, Canada, Chile, etc. But looking at it from the perspective of the investor, rather than thinking whether or not, you know, bilateral investment treaty or ISDS is fit for purpose, is the prior question not what is the better forum for the investor to properly stress test the determination made at the national level? And that answer may change depending on the jurisdiction. And you may arrive at a point where your starting point may not be ISDS, depending on the state, but for some states, ISDS actually is possibly the only practical and effective remedy open to that investor because of the way in which national security arrangements are made domestically. And what would you say to that?
That it depends. Yet again, I think that it's a very valid point, and it will depend on the jurisdiction in question. I think there is a risk from the perspective of the investor that in investment arbitration, though, the state will essentially say that we made a legitimate national security determination, but we are unable to tell you, the investor, or you, the tribunal, why? Because you are a bunch of foreigners, and we don't have the legal ability, frankly. We are prohibited by domestic law from telling you why. And that, generally speaking, is not available as a defense before a domestic court. But then, of course, domestic courts may be different in terms of how much deference they give to the policymakers, etc.
Professor Ortino, you wanted to come in? And I'll come to you, Sylvia, afterwards.
Yeah, I mean, on this point, I mean, there is an interesting mechanism which the EU has put in its recent FTAs, and it's in sort of the filter mechanism for the application of the prudential carve-out. So I think even if an investor, right, is confronted by the respondent argument that the prudential carve-out is applicable, then the question is taken away from the tribunal and it goes to the regulators, which I think jointly from the two contracting parties, and they decide. So there was an attempt to take away this sensitive policy area from the tribunal into the regulators. I mean, and I wonder whether this is something that maybe could also extend it to national security. So again, assuming there is an exception, right, and not every time that you find it, but you have an exception, instead of the tribunal having to deal with those issues, you somehow let this decide at the more political level between the two contracting parties.
Okay. I think it was a
Yes,
comment.
yes.
Yes.
Yes. Oh, well, yes, but I'm going to have to, yeah, first, and then we'll go to the
Thank
screen.
you. Sylvia Tanova, Pinson Masons. The question is to Marcus and perhaps to the gentleman from Arnold and Porter. So my understanding, and again, I emphasize understanding, is that the way Germany went about the rip out of Huawei from the 5G network is slightly different from the Sweden example. And if I understand correctly from colleagues who are in the telecom space in Germany, they did it via a contract or state contracts between the entity in Germany, the regulator, and the sort of the key telecoms operators, whereby the telecoms operators agreed to rip out any Huawei equipment by date X from, you know, from their sort of contracts, supply contracts, right, with the likes of Huawei, for which they would get compensation. Again, I emphasize this is just an understanding because these state contracts are confidential. But then that compensation that the likes of Vodafone or Telefonica would get may then, right, be used to compensate Huawei in the supply agreements, right, that flows sort of downstream. So if this is the fact pattern, and I emphasize it's my understanding, I haven't seen the contracts, do you think that then the manner in which Germany went about achieving perhaps a similar result to what Sweden did, do you think that should make a difference in terms of whether it's possible a breach of the China-Germany VAT? I appreciate I'm putting you on the spot here. You may not have seen the VAT, but just curious.
Well, assuming that there is a BIT, which I think there is between Germany and China, that also includes an investor state arbitration clause, which is not as restrictive as some Chinese BITs are, then UI will probably have assessed whether there is a viable claim or not. But I'm not aware of any such claim, and they probably will first see how the Swedish case goes before taking any further action.
I just want to give you an opportunity to come back, whether on Sylvia's question or the question prior to that. Apologies, I didn't see your hand in time.
Yes, thank you very much. Yeah, I was just wanting to mention that. So there's a clause that was presented where on prudential issues there's an agreement between the two hosts, the home and host state authorities. That is not a EU invention, and it's not very new. Has existed on the American continent for quite some time, for both tax and for prudential measures, as most of you in the room will know. I'm not sure that this is going to work particularly well. Not making any statements on behalf of the organization, but because the government that takes the measure related to national security might not be very much inclined to share these concerns and discuss them with the home state of the investor, especially if we look at the practical installation. So I'm not sure. I think this is an interesting solution to take out very technical questions out of the hands of the tribunal and give it back to the governments as regulators. But I'm not sure it's going to work particularly well for this scenario of national security issues. Thank you.
Thank you. Other questions?
But online, I think at least one.
Yes, yes, they are very big questions. So before I and existential questions about the system, but we will come to Sean. Is there anything else in the room anyone wanted to raise either on national security or some other aspect that you've heard? Right. So this will be familiar territory for most in the room. Sean Redden asks, and starting really on or using Diana's presentation as a launch pad for these questions, has any attempt been made to address public criticisms of ISDS, including lack of appeal, inconsistency between awards, costs for the host state in defending proceedings, and inability of civil rights groups to ISDS proceedings as third parties? And I think we should take this in stages. this has been ongoing for, these debates have been ongoing for a very long time, but perhaps I can kick us off with the ability of third parties to participate in ISDS proceedings. I mean, this is relevant to what we've been talking about today, because of course, for the last decade or so, there have been third parties who have wanted to have an opportunity to make submissions in individual cases, including submissions on the interpretation of investment standards. And we know that I'm currently working on a report for the IBA on this, so I can tell you that there have been over 100 such interventions in ISDS cases. There are no real guidelines as to how exercises of discretion are going to be sort of considered by tribunals, but it does give rise to very interesting questions as to whether the arbitral process is fit for this. Marcus, as a practitioner, what's your perspective on third parties in ISDS disputes? Say in the national security context, for instance.
I don't have any example in that
Yes.
context. I think the most frequent example that most practitioners have faced are those interventions by the European Commission in intra-EU cases.
You have plenty of experience in that context.
Where you typically, or in most cases, or at least in many cases, you get an application by the European Commission to join as amicus. Then you get the Commission's view, which is effectively always the same, and the case name will be changed. I do not consider this to be particularly valuable, I think, for tribunals, because the EU member state in defense will almost inevitably, because the positions are coordinated with the member states by the Commission, so the arguments are effectively pretty much the same. So in that sense, it does not really, I think, contribute anything to the discussion. And I think probably these are the majority of interventions by third parties by the Commission in intra-EU cases. So from that perspective, in that particular instance, I do not consider them to be too valuable.
Thank you. Joachim, I want to give you an opportunity. I'll come to Diana as well, because I'm going back to the point that you made, which was, the intention, for example, of states in the 1960s on FPS sort of pretty clearly set out. And then we had that mini debate as to whether or not there's a difference between an autonomous standard and a standard that just really reflected customary international law. I mean, where do you stand on third parties being given an opportunity to make submissions on the interpretation of a treaty standard? I just want to be very clear. I'm not talking about non-disputing states. I'm talking about non-state third parties making submissions on the scope of FPS or FET or whatever it might be in a specific context. For example, environment, media freedom, all of these issues have now arisen in cases.
Yes, thank you. It's an interesting question. But it's also a question for me. Governments ask us to carry out work for their interest. And so they haven't asked us this question yet. And so we simply haven't worked on this. And so I'm not sure that I can contribute something to that discussion, unfortunately.
Please, sir.
Yes, Álvaro Mistal from Porto.
Let's get you a microphone so that those online can also hear you.
Álvaro Nistal from Arnhem Porter. My question would be, would the answer that Marcus gave, for example, would be different if it's an intervention by a community that might be affected by the decision and such that the intervention is not seeking to provide an interpretation of the applicable BIT, but rather a different perspective on the facts of the case, on how the decision could affect them, or on how the facts put forward by the state and the claimant might differ from their own experience.
Yes, I mean, there may be maybe an arguable case. I'm just generally, I think, pretty reluctant when it comes to third-party interventions, because you will always have a certain perspective, but which may not necessarily always be very specific to the case. And in particular, if it's not very targeted, it's not very specific to the case, not embedded in the case narrative, and just a general view. To what extent the tribunal will be educated by any such view, which may only have to do with the specific case at its margin. I'm not sure. I've not seen too many cases where I've seen then an award where the tribunal gave the impression that it felt particularly educated by a third-party intervention. I have to admit, I have not done as you have, a broad and comprehensive study, but from what I have seen, which is definitely not comprehensive, I think the value that most tribunals have seen in these third-party interventions is relatively limited. Would you?
Yeah, yes. I mean, so far, and I think that's a part of the issue. It's not so much that there might not be a part to play for third parties, but that the way in which the system has developed has often led to a situation where even when third parties are permitted to participate, it's very limited, and tribunals limit themselves to paying lip service to what has been said. And, there's some pretty excoriating dissents from the likes of, Philippe Sands, etc., about how, in order for the system to be able to continue, there needs to be a more robust mechanism through which relevant submissions and evidence can be given. But of course, so this is very difficult in an arbitration. You're not before the European Court of Human Rights. This is a tribunal of first instance. It's not, the subsidiarity principle doesn't apply. So there is definitely a misfit between arbitration and the idea of third party participation. Other questions? Well, then I might, Marcus, just to stay with national security, and I'll come back to also Diana in a moment, but you mentioned essential security interests as an exception. What are the other ways that investment treaties seek to exclude national security issues from determination by a tribunal?
So other ways would be carve out of investment screening decisions from ISDS. So the Canada Egypt BIT, for example, that I previously discussed, had a carve out excluding foreign investment review decisions on acquisitions from ISDS. The tribunal in Global Telecom held that the proposed takeover did not involve any acquisition, as the investor merely attempted to convert its non-voting shares into voting shares. So the exception in that particular case did not apply, which is why this case was decided on the merits. By contrast, the 2012 China-Canada BIT, which may be the treaty in a potential claim by Hikvision, excludes all investment screening decisions under the Canada Investment Act. Additionally, some investment treaties may designate national security screening as a non-conforming measure, or NCM. These are measures which host states may still maintain, even if they do not comply with particular treaty obligations. For instance, the Australia-China BIT stipulates that its MFN and national treatment obligations do not apply to listed NCMs, which includes Australia's investment screening policy. Lastly, states may also indirectly protect national security interests by excluding specific sectors from ISDS. Certain strategic sectors and critical industries have become focal points of contemporary national security concerns, and there are a number of treaties which exclude specific sectors.
Marcus, thank you very much. Diana, I just want to take you back to your slides. We don't need to bring them up, but you showed to us a real concentration of cases in fossil fuels, renewables, and critical minerals. from your perspective, I mean, do you think there's a risk that ISDS is in practice constraining governments' existing or future climate policies?
So we have seen cases, for instance, if we look at coal phase outs, we have already seen cases, right? So, and then there has been also some interesting work on estimating how much more could come in this regard when you have to, for stranded assets and those type of things. So there are some researchers who think that there could be some massive risk of claims related to climate action. Exactly, sorry, could you recall, have I answered your question?
Yes.
I have a doubt now.
Thank you very much. Joachim, did you want to come in on that?
Yes, what I can say is that at the OECD there has been work on the consistency between treaty obligations as they stand and the Paris Agreement, so this has been quite extensive over the past years, and it deals with the question of whether the treaties do not grant a subsidy, an implied subsidy, by de-risking, and to what extent that is compatible with the agreement, 21C of the Paris Agreement that says no subsidies for fossil. And so this work is all documented on our webpage as well, and I encourage you to read it. But we haven't made an estimate in terms of numbers of the value of this subsidy and what that means for treaty specifically.
Thank you very much. Any last questions before we take a much needed coffee break? No, well then, please join me in thanking our panelists for their terrific contributions in getting us started today.